We have reached the appointed time and a quorum has been formed, so I would like to call the meeting to order. Please invite the government officials to join us. For the meeting held on the 4th of May, members raised a number of issues that we need to follow up. For details, please refer to legislative paper CB-2 1612/1415-01. And the administration has provided a written reply in Chinese. Please refer to legislative paper CB-2 1612/1415-02. And on the table, members, you should find another paper as from the Federation of Hong Kong Property Management Industry Limited, offering certain comments, and the administration's response to those comments is also tabled. Let me ask the government to introduce the relevant papers. Thank you, Chairman. On the at the meetings held on the 11th of April and the 4th of May, as the Chairman has said, we have provided our responses in writing, so maybe I should highlight some of those now. In respect of Section 30 and Section 31, and that is immunities and avoidance of self-incrimination. Any disciplinary hearing or investigation, if can be conducted in accordance with the Section 30, and anyone who are attending such hearings and testify in such hearings would enjoy the privileges and immunities as if it was a civil proceeding in the court of first instance. The purpose of offering the privileges and immunities is to protect the relevant persons so that they will not be liable for civil liabilities due to negligence and so on and so forth. This is so that they would be willing to provide the information or documents required in the proceedings. And if people are not offered protection against self-incriminations, then they may be unwilling to cooperate in the relevant proceedings. If the chairman of the discipline committee's order is not complied with, the appeal tribunal can impose a fine, impose other penalties, and suspend the license or revoke the license. And if that person is not a licensee, then the appeal tribunal can censure or reprimand the person. Last time, the members asked whether there are other penalties that can be invoked. With a reference to other relevant regulatory systems, for example, in the estate agent authority ordinance, there is no penalty or issue a reprimand, an open reprimand. we believe if one fails to obey the order of the appeal tribunal or to disclose relevant evidence, information, or documents, the nature is similar to a disciplinary offense. And therefore, we propose that the tribunal chairman can impose disciplinary sanctions. As for non-licensees, as there's no way to suspend or revoke the license concern, after making reference to other laws, we believe that issue an open reprimand would be appropriate and reasonable. Under Section 39, bracket 1, if someone provides materially false or misleading evidence in the proceeding of the appeal tribunal, and that is, if it's being dishonest, is an offense. According to the bill, it would attract a fine of $200,000 or 1 year's imprisonment on indictment, and if he's convicted under summary procedure, then a level 6 fine or $100,000 and 6 months imprisonment can be imposed. As for the penalties under Section 39, we make reference to other ordinances and the penalties therein. For example, EA ordinance and Section 55, and that their penalty levels are similar to the Section 39 in the present bill.
And then under the criminal proceedings ordinance, and we note that under Section 31, if someone, when taking an oath in accordance with the law, deliberately makes a misrepresentation in a material manner, that in any of the judicial proceedings, then if there is a conviction upon indictment, there can be a sentence of imprisonment up to 7 years and also a penalty. And the Director of Public Prosecutions can depending on the circumstances of the case, rely or choose to rely on the most appropriate provisions to take prosecution action. And if someone discovers that the interest that has been disclosed has changed in nature, then there is a need to make the rectification or make the amendment. If someone has direct pecuniary interest or indirect pecuniary interest or personal interest, then of course a disclosure is required. And concerning the committees, you can refer to Section 45(1), and then Section 46, bracket 9 of the bill stipulates that in fact the requirements apply to members of the committees as well as the appeal panel. So in other words, members need to make disclosures in accordance with Section 46, bracket 2. And then the appeal tribunal, Section 38, empowers the Secretary for Home Affairs to prescribe the appeal procedures. And so the Secretary will consider whether there is a need to, in the subsidiary legislation, prescribe the interest disclosure requirements and proceedings for members of the appeal panel and the appeal tribunal. Right, do members have any follow-up questions in relation to the information provided? Mr. Wu Chi-wai, please. Thank you. Chairman, we've received a submission from the Federation of Hong Kong Property Management Industry Limited. So is it that we will also deal with that? There's a written response. I think we would first deal with the written response, and then we will deal with the submission and the administration's response. All right, so concerning the explanation given by Mr. Kwok, do members have any questions? If not, then we can refer to the submission provided by the Federation of Hong Kong Property Management Industry Limited. Mr. Kwok. Yes, Chairman. With regard to the Federation's submission, we've already prepared a written reply. First of all, issuing licenses to property management companies, PMCs. Our principle is that we should not create necessary obstacles in the way for companies and practitioners to enter the market. And also there is a need to maintain a level playing field. And that's why we have a single tier licensing regime. This is to avoid creating any labeling effect. And also we have made sure that companies providing cleaning services will not be covered by the regulatory regime. So the principle is to avoid unnecessary putting unnecessary obstacles in the way. And concerning issuing licenses for the practitioners, we in fact want to provide qualifications benchmarks. We want standards and professional standards to be enhanced. So there is a two-tier licensing regime for PMPs. So on the one hand, we do expect and encourage existing practitioners to acquire more advanced qualifications, and then at the same time we hope that for those who do not possess formal qualifications, they can also join the market. And for Tier 1, we require a university degree or equivalent, and also certain years of service and professional qualifications. And for the second tier, and the requirements are lower. So concerning the composition of the authority, we think we have already struck the right balance concerning protecting the interests of the industry and protecting the interests of owners and the public. We have also put in place some transitional arrangements, and the arrangements are similar to those applied to estate agents. So there is a 3-year transitional period, and those practitioners who possess the licensing or who can satisfy the licensing criteria can directly apply for formal licenses during the transitional periods. For those who are experienced but who do not possess the relevant academic qualifications, they can get provisional licenses during the transitional period so long as they satisfy certain criteria, and they can continue to provide property management service. And then if they can finish a course prescribed by the authority within a 3-year period, and after they've produced a thesis or a report, they can get a formal license. And concerning the detailed licensing criteria and also the license fees, these will be looked at by the authority when it is set up. And when the authority draws up relevant subsidiary legislation, it will definitely take into account the views of the industry and other stakeholders. Thank you. Right, members? Any follow-up questions in relation to the submission and the administration's reply? Mr. Wu Chi-wai, Deputy Chairman. Thank you, Chairman. I think I wish to highlight one of the worries put forward by the Federation. Of course, it's good to have a licensing regime. But then concerning those who are qualified, those who can get Tier 1 licenses, maybe the majority of them are now working in the large companies, and there aren't enough qualified persons in medium and small sized companies. So according to the Federation, small and medium-sized companies won't be able to get enough qualified persons. So we may be convinced that there is an adequate supply of qualified practitioners. But what about the distribution? Is the distribution very uneven? And then second, the industry is concerned about the transitional arrangements. Now, it is said that practitioners can apply for provisional licenses near the expiry of the 3-year transitional period, and that means that these people will have about 6 years to make the necessary preparation. So I want to know whether it is the case that practitioners need provisional licenses when the legislation takes effect in order to carry out property management work. If that's the case, then how come we can have 3 plus 3? How come they can have 6 years to make preparations? And then the subsidiary legislation won't be available until the principal legislation has been passed. And the subsidiary legislation will be dealt with by negative vetting. So we can understand why the industry is so worried, because all the important details will be in the subsidiary legislation. But then as the subsidiary legislation will be dealt with by negative vetting, we don't know what impact there will be on the operation of the industry. So can I propose that the subsidiary legislation be dealt with by positive vetting instead? In other words, the subsidiary legislation can be passed and can take effect only when all the concerns and all the relevant issues have been sorted out? Because the industry is extremely worried about the details. Yes, Mr. Kwok, 3 questions in total. Thank you, Chairman. Mr. Kwok has, Mr. Wu rather has asked 3 questions. First of all, the distribution of qualified practitioners. Now, concerning the licensing requirements for PMCs, they will be laid down by the authority when it is set up, and so we do not have any information concerning the distribution of qualified personnel. But then according to the information we have, there should be an adequate supply of qualified people. And also, tertiary institutions will continue to provide courses so that there will be an adequate supply of personnel. And for small and medium-sized companies, they may not have people who can satisfy the Tier 1 license or Tier 2 license criteria. And that's why we have the transitional period, so that existing staff can, through pursuing further studies, acquire the necessary qualifications. Yes, I can understand that the industry may have some concerns because they do not know what exactly the details are, but then we will be talking to the management companies. We'll give explanations to them and try to allay their concerns, and then their concerns will also be relayed to the authority. And then concerning whether the practitioners will have 3 + 3 years. Now, after the commencement of the legislation, there is a 3-year transitional period, and practitioners can, during this period, at any time during this period, apply for a license from the authority. And so if they apply at a rather late stage in the 3-year period, then they can have up to 6 years, almost 6 years, to make necessary preparations. For example, to take certain professional development courses and so on and so forth. And so they can start preparation as soon as the legislation comes into effect. So in fact, they can have 3 + 3 years, the longest, to make preparations.
Mr. Kwong, are you saying that for the first 3 years after the enactment of the law, there's no need to hold a license? Well, after the new law comes into effect, there's a 3-year transitional period during which anyone can apply for a provisional license. So they can apply at the latter part of the 3-year period. And I understand Mr. Wu's concern in his third question. Yeah, the future authority will come up with licensing criteria, and it will certainly have regard to the situation in the industry, and will communicate with the relevant stakeholders. I believe the relevant subsidiary legislation will be the result of taking on board the views and of the industry, and also after careful consideration of the relevant factors. Well, the details will be come up with have to be devised by the authority. Concerning whether it should be negative vetting or positive vetting, can you give us some example? For example, Tier 1 license, Tier 2 license, and the requirements for different licenses. There will be a 3-year transitional period. So you're certainly not going to consider positive vetting for that? Earlier, in an earlier reply, we have already set out our view. The public would like to see the bill enacted as soon as possible. So when the authority is up and running, and when they have drafted the subsidiary legislation, the relevant regulation will be tabled in this council for vetting. And before that, they would communicate with the stakeholders as well as legislative members. So we believe that the current proposal that we are having, that we have, is appropriate. Mr. Wu Jiwai, on the question of distribution of practitioners, the government is of the view that on the whole the number is sufficient. I would like to get some information on where they are, the distribution of the practitioners. Although we don't know the details such as the licensing requirements, but on the whole, for Tier 1 and Tier 2 as a whole, we have already got a rough idea of the licensing requirements. My concern is that after this becomes law, it would be a situation whereby the big companies would take over smaller ones. We have to scrutinize the bill within this month or so, but we don't know what the subsidiary legislation is going to be like. So let's ask the government to give us some information so that when we pass this into law, we have a rough idea of the distribution of practitioners, whether this will lead to the taking over of smaller companies by the bigger ones, and whether we think that there will be sufficient number of practitioners. Is that really the case? In other words, according to the government, so they can continue to work without a license. I just want to clarify whether they are allowed to go on with their operation without a license in the transitional period. And you know, there are practitioners who are not qualified but hold experience. There's no reason to allow people not even equipped with a provisional license to continue to work in the industry. I remember in the case of Chinese medicine practitioners, well, those who are not provisionally registered were not allowed to continue with the practice. Deputy Chairman, well, when it comes to the licensing requirements, they may have some rough ideas, but the details would have to be set by the authority. And there are big companies and smaller companies. And of course, bigger companies enjoy a certain market share, but so do the smaller ones. We don't know the relevant share that big or small companies own, and we need to define which are big and which are not big. Is my understanding correct, Assistant Director? Well, yeah, your understanding is correct. Much will depend on the criteria set by the authority. At present, we're talking about management practitioners, property management practitioners. I believe most of the incumbent practitioners will be able to be licensed in the future. So on the whole, it will not give rise to a situation whereby the management companies cannot employ sufficient numbers of practitioners or manager. But we would try to get some figures and statistics from the relevant property management companies for members' reference. Please also respond to the question on the transitional arrangement. Yes, there will be a 3-year grace period or transitional period. So we will count 3 years from the commencement days, and then everyone will have to be licensed from that point onward. So we need to provide time, allow time for people to get licensed, as I've said, they can apply for a provisional license anytime during the transitional period, or if they are already qualified, they can apply for a full license. So they will not be regarded as operating without a license during the transitional period. Please clarify. After the law is passed, of course, you will have to set the commencement date. Theoretically, you have to wait until the authority is established and it has come up with the licensing requirements. So you have to wait until the authority is set up, and only after the licensing requirements are already set, and then the authority would have to come up with the necessary subsidiary legislation, and then you start to count the transitional period. And before that, there's no system in place whereby you can say that someone is licensed and someone is not. Is that correct? Yes, Mr. Wu's understanding is correct. We need to pass the bill first, and then we have to set up the authority. The authority would have to draft the subsidiary legislation. That takes time, and then the subsidiary legislation has to be vetted by this council, and then after that we will have to commence the transitional period. We cannot say that at that point that if you don't have a license, well, you cannot operate anymore, because even for those who are qualified to apply for a license, they need time to apply for a license. So we cannot say that everyone must be licensed at the commencement of the transitional period. That period of 3 years would enable the authority to process licensing applications and grant licenses to the property management practitioners. So after the expiry of the 3-year period, we require everyone to be licensed. So if someone who only applies at the late stage of the transitional period, then they would have more time to prepare, so that they would ultimately be able to satisfy the licensing requirements. All right, further questions? So do we have other questions concerning the two papers set on the government's responses? If not, then we can continue with our cross-by-cross examination. It's a page by part 7. C2814 for the Chinese version. Mr. Guo? Oh, I would ask my colleague Mr. Wong to do it. Thank you. It's a cross 41. Or 47, delegation by authority. 1, the authority may delegate any of its power to a committee of the authority. B, the CEO, or C, the holder of any office in the authority designated by the authority. 2, however, the following powers must not be delegated. A, the power conferred by subsection 1 to delegate. B, the power conferred by section 23 of Schedule 3 to establish committees. C, the power conferred by this ordinance to make regulations. And brackets 3, a person purporting to act in accordance with the delegation under subsection 1 is presumed until the contrary is proved to be acting in accordance with the terms of the delegation. Thank you. Please continue. Yes, Mr. Yip Kwok Kim. For a committee of the authority, do you also cover working groups under the authority? Mr. Wong, Mr. Kwok? Here it states that the powers can only be delegated to a committee. How many committees do you have? If you look at Schedule 3, The only standing one is the one on disciplinary committee, but the authority is empowered to set up other committees. So there's no cap on the number. They can have as many committees as the authority wants. We don't have a restriction on the number of committees that can be set up. The authority can decide how many committees should be set up. What about the membership of the committees? Is it restricted to members of the authority? Or you can appoint some other people? Would the membership be restricted, or is it really not limited? Actually, on the composition, please refer to Schedule 323. Well, a committee must have at least 3 members. There can be people not member of the authority. But if there's a mixed composition, more than half of them must be members of the authority. We can proceed to a more detailed discussion when we discuss the schedule. In other words, you can appoint members of committees of the authority who are not members of authority. Mr. Wong, if there's no question from other members, clause 48. Directions by Chief Executive. The Chief Executive may give the authority written direction for performing any of its functions if the CE is satisfied that it is in the public interest to do so. That's under clause 48, bracket 1. Bracket 2.
The authority must comply with a direction given under subsection 1. And then 3. This section does not enable the CE to exercise power or control in relation to A particular application or any other matter with which the authority or a committee of the authority is concerned, or B, a particular case with which an appeal tribunal is concerned or which is pending. Then 4. Directions given under subsection 1 are not subsidiary legislation. Right, I think you can continue, Mr. Wong. We want to deal with Schedule 3 first, and then we'll deal with Part 8. Yes. Schedule 3.1, Interpretation. In this schedule, ordinary member means an ordinary member of the authority appointed under Section 2 of this schedule. Yes, please continue. Clause 2, appointment of members of authority. The authority is to consist of the following members: the chairperson, the vice chairperson, not more than 18 ordinary members. Every member of the authority is to be appointed by the chief executive from among the following categories of individuals. A. Individuals who are engaged in property management services, Category 1 persons. Then B. Individuals not being Category 1 persons who, because of their experience in property management, general administration, or consumer affairs, appear to the CE to have knowledge of property management services, Category 2 persons. C. Individuals not being Category 1 persons or Category 2 persons who appear to the CE to be suitable to be appointed as members of the authority, Category 3 persons. And then, in appointing a member of the authority, the CE must ensure that at least half of the ordinary members are Cat 3 persons, and B, for the other ordinary members, so far as possible, half of them are Category 1 persons and half of them are Category 2 persons. And for subsection 3A, if at any time the number of ordinary members is odd, that number is to be taken as having been increased by 1. And then public officers are eligible to be appointed as members of the authority. Thank you. concerning the proportion of Cat 1, Cat 2, Cat 3 persons, some organizations have suggested that there should be a larger proportion of members who are Cat 1 persons. Mr. Wong, please. Yes, thank you. With regard to the composition of the authority, now we want the authority members, of course, to know the industry, and then we do not want to have the industry regulating the industry. So we have 3 categories of individuals. First of all, individuals who are engaged in property management services, and then individuals not being Cat 1 persons, who because of their experience in property management, general administration or consumer affairs appear to the CE to have knowledge of property management services. And then Cat 3 persons, individuals not being Cat 1 persons or Cat 2 persons who appear to the CE to be suitable to be appointed as members of the authority. And we think it is appropriate to have half of the members who are or at least half of the ordinary members who are Category 3 members. As I've said, we do not want to have a situation whereby we have the industry regulating itself. As Chairman, what does it mean when you say if the number of ordinary members is odd, that number is to be taken as having been increased by 1? Can you give an example? Say if there are 9 Cat 3 persons on the authority, then what is meant by the number is to be taken as having been increased by 1. Now say if the number of ordinary members is odd, say 17, then the number is to be taken as 18. But then if the number is even, then this subclause does not apply. So are you talking about the quorum here, or are you talking about the situation where a vote is taken? Now we have said that at least half of the ordinary members are Cat 3 persons, and then for the other ordinary members, half of them are Cat 1 and half of them are Cat 2. And so just to say that if the number of ordinary members is odd, then that number is to be taken as having been increased by 1. So you shouldn't have used the example 17 members. What about 9 Cat 3 persons? And then Cat 1, 5 persons, Cat 2, 5 persons, and then Cat 3, 9 persons? Perhaps I can try to explain. Mr. mentioned the figure 17. Now under 3A, half of the ordinary members are Cat 3, and that would mean 8.5 if the total membership is 17. And so we'll have to add 17 by 1, increase 17 by 1, then 18 members, because we can't have 8.5 members who are Cat 3 persons. So in other words, out of 18, 9 persons are Cat 3 persons. And then half Cat 2, half Cat 1. So this is to make the arrangements. So 3B says as far as possible, but 3A says at least half of the ordinary members are Cat 3 persons. Because for Cat 3 persons, at least half of the ordinary members are Cat 3 persons, and some in the industry are worried that maybe the majority, the overwhelming majority of ordinary members will be Cat 3 persons. Now, you don't want to have the industry regulating itself, but then the industry is worried that if there are too few people representing the industry sitting on the authority, that would also create problems. So will there be a situation whereby the overwhelming majority of the ordinary members are Cat 3 persons? Half of the members should be Cat 3 persons, and then 1/4 Cat 2 or 1/4 Cat 1, and that's our thinking. And I don't think the industry needs to be too worried. In fact, we've already explained to the industry that that's the composition formula that we have in mind. Mr. Ip Kwok Him. But what if there is a tie when a vote is taken? So maybe there are 20 members, all right, a chairman, a deputy chairman, and then 18 ordinary members. And what if there is a tie when a vote is taken, 10 to 10? Mr. Kwok. In fact, that's in Schedule 3, Clause 11. All those who are present at the meeting of the authority each has one vote at the meeting. And then if there is a tie, then the chairman can now have a casting vote. All right, so any other views, Mr. Paul Chair? Clause 48, Chairman, says that the CE may give the authority written directions for performing any of its functions. But of course, the CE cannot give instructions on a particular application or a particular matter. But still, the CE can give the authority some written instructions for the performing of its functions, and the authority needs to comply with this direction. You know, for this authority, it has very important functions. It is responsible for regulating the property management industry. So, what for what policies or areas of policies does the CE need to give the authority written directions, or is it just a fallback power? Because I think the powers that the CE has under Clause 48 are very great. And I want to know whether for other statutory bodies, the CE also enjoys this fallback power. Yes, thank you, Chairman. Thank you, Mr. Chair. Let me answer the second question first. In fact, this provision can be found in legislation governing other regulatory bodies. As Mr. Chair has pointed out, this is really a fallback power. In most cases, the authority can discharge its duties under the powers that it enjoys. So, in fact, it is not that we have certain policies in mind for which the CE needs to give directions. In fact, it's just a fallback power. Mr. Paul Chair. So we are told that this provision is very common and is commonly found in legislation governing regulatory bodies. So can I try to get some examples of the CE having given or issued directions to regulatory bodies for the discharge of their functions, or is it that it's just that this is just a fallback power and is seldom used? I think I'll have to go and do some research here. Thank you. Thank you. Yes, Mr. Wong, please. Schedule 3, Clause 3. Each member of the authority is to be appointed for a period not exceeding 3 years that is specified in a member's letter of appointment, blah, blah, blah. And then the CE may determine the terms of appointment, including remuneration and allowances. And the remuneration and allowances of a member are to be paid out of the funds of the authority. And then the CE may this is Clause 3, terms of appointment. The CE may determine the terms of appointment and then remuneration and allowances to be paid out of the funds of the authority. Concerning remuneration and allowances, yes, yes, can you repeat? Remuneration and allowances. So they are to be paid out of the funds of the authority. So is it that the government will provide funding for the authority?
So what are the funds of the authority? Well, it comes from the levy. It's in Part 8. There's a levy on every property transaction. So that's one of the revenue sources. And then we have the revenue from licenses. Application, there's the need to pay application fee and also the license fee. Well, suppose the revenue is insufficient to pay the remuneration and allowances. Will the government bridge the gap? Well, the authority is supposed to be self-financing. There will be no need for the government to inject funds because this is established under the user pays principle. So the authority would need to adopt prudent financial management, and they have to submit the financial reports to the Director of Bureau and to this Council for scrutiny. So we do not want the authority to offer remuneration and allowances that it cannot really pay. What if they are short of funds? Are you saying that the government would not provide support in any case? They will have to increase their revenue before they are able to pay. So are you saying that they can increase the levy? Well, this may be hypothetical, but it could well happen. Well, a body like this may be given a style of funds, some seed money, but they have to sustain the operation. I don't know how much the CEO is going to be paid, but usually it's not low. Are you really confident that once this is up and running, the revenue for the authority will be sufficient? And you also have to hire other staff. It's going to be a a big sum of money that you need to spend. We have estimated that during the initial stage, well, the authority may need a certain level of funding. That would also determine the levies that we are going to impose, and also the licensing fees as well. Well, if the authority doesn't have sufficient funds, then it may have to consider increasing the fees and the levy. And at the same time, it must be responsible for prudent financial management. We have other members in the queue, so please be succinct, Mr. Yip. Well, after the authority is up and running, is it correct to say that there will be no government injections of fund? Well, we may give them some assistance in the initial stage, but in the long term, they should be self-financing. That's the policy intent. Are you going to inject funds? They need money to sustain the operation. What about the initial seed money? Do you provide an initial startup fund? Well, the usual practice is to offer a loan, and then when the authority is fully established and is run smoothly, the loan will be repaid. Mr. Wong Kok Heng, 5 minutes, because we have someone in the queue as waiting to ask questions. First question. Do you have any stipulation on the 6-6 appointment principle and the observance of such a principle? That's question number one. And second, you are going to offer remuneration and allowances. But what if someone is appointed to more than a position? But would he get remuneration and allowances all the same? Well, the appointment is for a period not exceeding 3 years. As for the 6+6 principle, is an administrative principle. Appointments will be made with regard to that principle. For remuneration, ordinary members will be treated the same. But that's not a criterion for appointment. We'll just appoint the most suitable persons. I don't think my second question has been answered. My concern is that a person may be paid by virtue of his appointment to the authority, but that person is also remunerated through other positions. So would the same person be remunerated twice or even 3 times? It could well happen, because that person may have some unique expertise which the government would like to make use of in this authority and in other statutory bodies. Do you allow this, or are you going to avoid this as far as you can? Members of the authority is not executives. They are not really running the day-to-day operations of the authority. So the remuneration and allowances might well just be nominal. If that person, that member, is holding a different positions elsewhere, that person has to fulfill his responsibility when he works for the authority, so he will be remunerated as a member. So we'll consider whether they are appointed as one of the categories, or would you allow the person to be remunerated for more than one position, whether it's nominal or not? The person may hold 2 or 3 different positions. Do you allow the same person to be remunerated for all those positions? Well, if the same person is appointed to different statutory bodies or authorities, will he be remunerated? When a person is appointed to spend time in the work serving a certain authority, then the remuneration is paid for the purpose of his service with the authority. If at the same time he's also serving in another authority, that other authority may also provide remuneration. But this is not a reason, a criterion for whether we would appoint him or not. In other words, a short answer would be yes, that's allowed. For example, if he's also a member of the Town Planning Board, that person may get a remuneration from another position.
咁多新啦。
簡單答啦，即係話。
So maybe the concern is that the member cannot really take up so many different positions. Well, when we make an appointment, we will first of all consider whether the person is from the 3 category concerned, and also whether he's also concurrently holding other public offices, and then he may not be may not be able to manage time-wise. And if he doesn't have time to participate in the work of the authority, that would be a consideration. Mr. Alan Leung, we have at most 20 authority members, and they come in 3 categories: chairman and a deputy or vice chairman. There's no regulation, there's no rule stipulating that the chairman or vice chairman must come from a certain category, one of the 3. But there's no stipulation on which category it must be. Follow-up? Chairman, you know that the industry has offered a lot of comments. Is it that they don't have strong views? The government has been saying that you don't want to give people an impression that is regulation by the industry. That's why half of the members, ordinary members, are Category 3 persons. If you allow a Category 1 person as chairman and then a Category 2 person as vice chairman, is that all right in the government's consideration? Well, we have to consider whether the appointee is familiar with property management and the person's experience, and whether he has made any significant contribution to the industry. So we don't have hard and fast rule as regards whether the chairman or vice chairman is a Category 2 or Category 1 person. The policy of not allowing the industry to regulate itself is implemented through the appointment of ordinary members who are Category 3 persons. But that's okay. Now I know that the government has no preconceived idea about who should be chairman or vice chairman of the authority? I just want that answer for the record. And then I want to put this to the government to see if they agree with me. This authority, Property Management Services Authority, will be established in accordance with Schedule 3 of the current bill. It's a body corporate, and if, or it's a big if one day it's not solvent, it's insolvent, and then it may be declared bankrupt, or it may be dissolved. Well, as a body corporate, that possibility is always there. Ms. Choi, yes, it's a body corporate. It will show the liabilities on its own. It can be sued, or it can be a subject of different petitions, including a bankruptcy petition. Mr. Yip Kwok Kim, I want to follow up another point. You have talked about the sources of revenue, and then in the provisions you talk about the members may receive remuneration and allowances. We have a lot of statutory bodies, Housing Authority, Urban Renewal Authority, and the like. There are so many of them. For some of these authorities, there are clear stipulations that no remuneration will be provided. Of course, some of the members do not care. Is it too much to provide remuneration to members? Or you are going to have a CEO. Of course, CEO is going to be remunerated. I don't know whether other authorities also offer remuneration. Well, I have participated in quite a few. I haven't heard that the chairman of an authority is remunerated.
So, for the chairman of the town planning board, he is the permanent secretary. I understand that an honorarium is provided. So can Mr. Kwok please explain? Chairman, under the competition ordinance, there is a similar provision. So it also says that the CE may determine the terms of appointment, including remuneration and allowances of the members of the competition commission. But is it that they, in fact, the members of that commission do not get a remuneration? No, in fact, the CE may determine the terms of appointment, and the terms of appointment may include remuneration and allowances. And as to whether remuneration and allowances are offered, it really varies from commission to commission. Now, I think it's okay to have allowances, but then not remuneration. Because the public may find it very strange. Oh, because this is a public office, and how come there can be remuneration? And I have cited the example of the competition commission, and for the other statutory or regulatory bodies, the members do not get any remuneration, although they may get allowances. Yes, we'll further consider this suggestion. Because Mr. Ip is concerned that the word remuneration may suggest that these members are like staff, are like the staff. Mr. Alan Leung, no, I don't mind the name or the term, but how much will be given to the members? Is it only an honorarium? No, I don't mind you're calling it remuneration when you're only providing a transport allowance or subsidy. But then if the amount is $300,000, then that of course is not an honorarium or an allowance. In fact, we have in mind, Chairman, an honorarium or a traveling allowance. So please follow up on Mr. Ip's point and then come back with a reply. I think we need to be accurate with regard to the terms we include in the legislation. Because for the CEO, yes, I can understand that he needs to get a remuneration, say $300,000 a month. But then for the authority members, they should not get any remuneration. I think they can only get an honorarium or an allowance. All right, so Mr. Kwok, please look at this. Yes, any other questions, Mr. Wong Kwok Heng? I do not support the use of the term remuneration either. Either use the word honorarium or the word allowance, because if you use the term remuneration, then it follows that there should be a value for money studies or audits. All right, yes, we will, Chairman, look at the wording again. Yes, you can continue, Mr. Wong. Clause 4. A member of the authority may at any time resign from office by giving written notice of the resignation to the CE. Then a notice must be signed by the member. And the notice takes effect on the date on which notice is received by the CE, or if a later date is specified in the notice, that later date. Thank you. Any questions? No? Then please continue, Mr. Wong. Removal from office. The CE may remove a member of the authority from office if the CE considers that the removal is desirable for the authority to effectively perform its functions. That if a member of the authority is removed from office under this section, the CE must give the member written notice informing the member of the removal. Thank you. All right, members, any questions? No? Mr. Wong, then please continue. Then, if for any period the chairperson is temporarily absent from Hong Kong or for any other reason temporarily unable to perform the functions of the office of chairperson, the vice chairperson is to act in the place of the chairperson during that period. Yes, please continue, Mr. Wong. Clause 7. Power to employ staff, etc. The authority may appoint a person it considers suitable to be its CEO or other officers or employees. And B. Engage on a contract for services a person it considers necessary to perform its functions. 2. The authority may determine A. the remuneration and other conditions of employment of its staff, and B. the remuneration and other conditions of engagement of persons engaged on contracts for services. Then 3. The authority may provide and maintain schemes, whether contributory or not, for the payment of retirement benefits, gratuities, or other allowances to its employees or former employees and to their dependents. Right? Any questions in relation to clause 7? Mr. Kwok Kim, I want to go back to clause 6. Yes? Now, if members have no questions on clause 7, I want to go back to clause 6. Yes. The chairperson being temporarily absent from Hong Kong or for any other reason temporarily unable to perform the functions of the office of chairperson. Then does it mean that if he is temporarily absent from Hong Kong, then the vice chairperson has to act in the place of the chairperson during that period? Because in fact, technology is so advanced. There can be video conferencing, teleconferencing. So I just want to clarify this point. Is it that the vice chairperson has to be the acting chairperson if the chairperson is temporarily absent from Hong Kong? Or is it that the vice chairperson needs to act as chairperson only if the chairperson cannot perform the functions of the office of chairperson? Like if the chairperson is out of town, then the vice chairperson will be the acting chairperson. As I understand that there is video conferencing, teleconferencing. But then if the chairperson is out of town, we can't be sure as to whether we can contact him and whether he can discharge certain functions of the chairperson. So we want to avoid such uncertainties. And so if the chairperson is not in Hong Kong, then the vice chairperson will act in the place of the chairperson. But I think this proposed arrangement is outdated given the present state of technological development. In fact, because of advanced technology, you can contact the chairperson anytime. I think the vice chairperson needs to act in the place of the chairperson only if the chairperson can't be contacted. I think if the chairperson is not in Hong Kong and cannot perform the functions of the chairperson, then there is a need to have this acting chairperson. In fact, I have served in many advisory and statutory bodies, and in fact, nowadays it's very easy to contact the chairperson even if he or she is physically out of town. In fact, we have made reference to the arrangements for other statutory bodies. All right, any other views? Mr. Wong, I think you can continue. Clause 8, meetings. General procedure for meetings. Meetings of the authority are to be held at times and places determined by the chairperson or, in the chairperson's absence, the vice chairperson. And then second, the procedure for convening meetings of the authority and for the conduct of business at those meetings is subject to the schedule to be determined by the authority. Thank you. All right, any questions? And then you can continue, Mr. Wong. Clause 9, quorum for meetings. 1. The quorum for a meeting of the authority is 1/2 of its members. 2. For determining the quorum, a member of the authority who participates in the meeting by telephone, video conferencing, or other electronic means is to be regarded as being present at the meeting if that member is able to hear the other members who are actually present at the meeting, and the members who are actually present at the meeting are able to hear that member. Mr. Kwok-Kim? So if the chairman is not in Hong Kong, can he chair the meeting through video conferencing? Because he is regarded as being present at the meeting. Can he chair the meeting? But then, Chairman, in clause 6, there is the arrangement for having an acting chairperson. But then I think we can look at the whole set of arrangements again in the light of Mr. Ip's concern. Oh yes, the deputy of the vice chairperson can of course act in the place of the chairperson, but say if the chairperson is in the UK, in fact he can chair the meeting through video conferencing arrangements. So is it that you should still have the acting chairperson chairing the meeting when in fact the chairperson can take part in the meeting? It depends on how clause 6 is to be interpreted. Yes, Chairman. Clause 6 is about a situation where the chairperson cannot attend the meeting, and so the vice chairperson takes his place. But of course, we'll look at clauses 6 and 9 together. Legal advisor. Concerning clause 9.2, authority members taking part in the meeting through electronic means, then can we be informed as to what measures the authority will put in place to make sure that the discussions can be kept confidential?
In an earlier written response provided the Bills Committee, well, we said we would be making reference to the relevant guidelines of the Communications Authority to ensure confidentiality of the meeting and the proceedings. Thank you. Other members? Mr. Wong, please continue.
3第10條訂明，監管局會議由以下人士主持。
A meeting of the authority is to be presided over by A, the chairperson, B, if the chairperson is absent, the vice person, or C, if both the chairperson and vice person are absent, one of the members of the authority elected by the members present. No, there's no question. Please continue. Voting at meetings. 11. Bracket 1. Subject to subsection 2, each member of the authority who is present at a meeting of the authority has one vote at the meeting. Bracket 2, the member presiding at a member of the authority has a deliberative vote and also has a casting vote if the number of votes for and against a motion is equal. Bracket 3, the member presiding at a meeting of the authority must ask each member who is present at a meeting to indicate how he or she has voted. Bracket 4, the result of the vote showing which way each member has voted must be recorded in the minutes. Bracket 5, a decision supported by a majority of the votes cast at the meeting of the authority at which a quorum is present is the decision of the authority. Questions, members? Mr. Wong, please continue. 12. The authority must maintain minutes of the proceedings, including a record of all decisions made at each meeting of the authority. Please continue, Mr. Wong. 13 is about written resolutions. Bracket 1, the resolution is a valid resolution of the authority even if it is not passed at a meeting of the authority if A. It is in writing. B. Proper notice of it is given to all members of the authority. And C. It is signed or sent to by a majority of the members of the authority by letter, fax, or other electronic transmission. Bracket 2. Subject to subsection 3, the date of a resolution referred to in this section is the date on which the last of the members of the authority constituting a majority of the members signs or assents to the resolution. Bracket 3. If any member of the authority requests by written notice addressed to the chairperson that a resolution proposed to be made under subsection 1 be referred to a meeting of the authority for consideration, the proposed resolution must be referred to a meeting of the authority. Bracket 4. A request under subsection 3 must be made within 14 days after the day on which the notice referred to in subsection 1b is given. Questions, members? Mr. Yip Kok Kim. Thank you, Chairman. Written resolutions are voted on, right? So you make a decision. And you vote on it. Would it lead to a situation whereby many important decisions are made by written resolutions, and there's no detailed discussion by the authority? So people may think that it's a bit, not a bit insolemn. So are you going to adopt this arrangement for not so important decisions? Or is it always the case that the decision can be made by a simple majority of the members? Sometimes you may not be able to convene a meeting. Sometimes time is limited, and you want to do it through a written resolution. And is a simple majority good enough in such cases? Whether it's in a meeting or it's done through a written resolution, a simple majority will suffice. Sometimes a resolution in writing is passed because of time constraints. But as long as a member thinks that the matter must be discussed at a meeting of the authority, then under bracket 3, he can give a written notice to the chairperson to refer the matter to a meeting of the authority. So the members can always ask that the matter be discussed in a meeting of the authority. Further question, Mr. Yip? No. Legal advisor. Well, should there be some stipulation that in section 3C, and then subsequently there's another request under 13 bracket 3 for the referring the resolution to a meeting of the authority, then the resolution in 1C would lapse? Or we agree with the legal advisor, will move suitable amendments to give effect to that. Please clarify this. According to our legal advisor, you may have a majority of the members consenting to a resolution, and it's regarded as a valid resolution, and then subsequently a member asked that the resolution be referred to a meeting of the authority. What would happen if you make reference to similar provisions in the Communications Authority Ordinance, and if a paper is being circulated for consent? And then subsequently, there's a request for the matter to refer to a meeting of the authority. Then the agreed resolution through circulation will not be valid anymore. So I would like to have a clear stipulation in this section, saying that in such a case, the resolution will be invalid, will not be valid anymore. What if the past resolution has already been announced? Well, the time frame is 14 days. The request must be made within 14 days and not later than that. Yes, a member must make such a request within 14 days, and not later. Questions? Mr. Wong, please continue. Section 14. Decisions not invalidated by defects in appointment, etc. A. Decisions of the authority are not invalidated solely by A defect in the appointment of a member of the authority, B. A vacancy among the authority's members, C. The absence of a member of the authority from the meeting at which the decision was taken, or D. An irregularity in the procedures adopted by the authority that does not affect the merit of the decision taken. Questions from members on this particular clause? If not, Mr. Wong, please continue. Section of clause 15. Financial year. The financial year of the authority is A. The period beginning on the date on which this section comes into operation and ending on the next 31st of March, or B. The period of 12 months ending on 31st of March in each subsequent year. Please continue. 16. Funds. 1. The funds of the authority consists of A. All the money received by the authority by way of fees, levies, and penalties, and B. All other money and property, including interest and accumulations of income, lawfully received by the authority for its purposes. 2. Any funds of the authority that are not immediately required by it for the performance of its functions may be A. Deposited on fixed term or call deposit, or in a savings account in a bank nominated by the financial secretary, either generally or in a particular case for that purpose, or B. Invested in a manner approved by the financial secretary. Thank you, Chairman. Mr. Yip Kwok Kim, under B, my understanding is that the financial secretary can approve other manners of investment, for example, in stocks, funds, and so on and so forth. Is that correct? Mr. Kwok? Well, of course, the proposed investment method would be from the authority, and then the FS would give approval. For A, it's a fixed term deposit or call deposit. For B, it's a wide scope. The authority can propose any investment method for the approval of the FS. I think, in other words, if the authority wants to invest money in ways other than those in A, approval by the financial secretary is required. But there's no restriction here as regards what the FS may approve. Clause 17. Authority is exempt from taxation. 1. The authority is exempt from taxation under the Inland Revenue Ordinance, Cap 112. 2. To avoid doubt, subsection 1 does not apply in relation to any remuneration, benefits, or expenses paid out of the funds of the authority to a member of the authority. Questions? No questions? Please proceed to the next part. 18. Accounts. 1. The authority must A. keep accounts and other records that accurately record and explain the financial transactions and financial position of the authority, and B. ensure that a statement of accounts is prepared within 3 months or a longer period the Secretary allows after the end of each financial year of the authority. Bracket 2. The statement of accounts must give a true and fair view of A. the state of affairs of the authority as at the end of the financial year, and B. the results of the operations and cash flows of the authority in that financial year. No question from members. Mr. Wong, please continue. 19. As soon as practicable, after the date on which this section comes into operation, the authority must appoint an auditor to audit its statement of accounts. Bracket 2. The auditor must, as soon as practicable after the end of each financial year of the authority, A. audit the accounts and statement of accounts required under Section 18 of this schedule, and B. submit a report on the statement of accounts to the authority. Mr. Wong, please continue. 20. Section 20, Annual Report. Bracket 1. As soon as practicable, and in any case within 6 months after the end of each financial year of the authority must prepare a report about its activities in that financial year. Bracket 2. The report must contain the following information in relation to that financial year. A. An outline of the investigations conducted by the authority. B. A summary of complaints received. C. An outline of all proceedings brought before appeal tribunals. Members, any questions? Legal advisor? In respect of 20 bracket 2, it's a summary of all disciplinary proceedings conducted in accordance with Section 23 be required in the report. On this question, we have agreed that the annual report should contain the summary information of disciplinary hearings conducted in that financial year. We are going to move a CSA to give effect to that. On this question of disciplinary hearings and appeals, can we really search and search for and have access to the records and the decisions? For example, can you go to the authority or some other locations, and then we can search for different cases. For example, the particulars of the case and the basis of the conclusion or decision, and also the penalties imposed. Can we have access to all these information in the cases?
Chairman, under clause 13, there are registers, and so if there are rulings on the companies, then these will be included in the registers, and the registers are available for public inspection. And concerning the annual report, we're talking about an outline and a summary of the investigations, and also a summary of complaints, and an outline of all proceedings brought before appeal tribunals. Clause 20, annual report. You said it's just an outline of all proceedings brought before appeal tribunals. But I believe you do expect your authority to, over the years, accumulate some judgments or rulings. And such information will be a very useful reference for the management companies and other parties. So I think for rulings as well as outcome of appeals, so there should be a set of full records. This is the practice in the Inland Revenue Appeals Tribunal. Yes, thank you, Chairman. Yes, I want to say that there is such information available. As to whether we have the complete ruling, I think I will look at the practice for other regulatory bodies, and then I'll report back to members. I agree with Mr. Alan Leung. I think such rulings are important information for the public. But then we have to look at the format. Maybe the public may not find the rulings, the judgments very easy to understand. Chairman. I believe you will not ask a member of the public to read a CFA judgment. But then I think it's important that the original records are important. For OCs, which need to hire property management companies, I think it's a good idea to help them understand the content of the rulings, which may be rather difficult, but at the same time, I think there is a value in providing the full judgments or rulings to the public and to OCs for their reference. Thank you. Clause 21 of Schedule 3. This is on annual report and audited accounts to be laid on the table of Legislative Council. 1. As soon as practicable and in any case within 6 months after the end of each financial year of the authority must give the following documents to the Secretary: a copy of its annual report prepared under Section 20 of this schedule. And then B, a copy of its statement of accounts, and C, a copy of the auditor's report on the statement of accounts. 2, the Secretary must arrange for the documents received under subsection 1 to be laid on the table of the Legislative Council. Thank you. All right, do members have any questions? No? Mr. Wong? Schedule 3, Clause 22, Director of Audits Examination. The Director of Audit may, for any financial year of the authority, conduct an examination into the economy, efficiency, and effectiveness with which the authority has used its resources in performing its functions. 2. For the purposes of conducting the examination, the Director of Audit may, at all reasonable times, have full and free access to all accounts, records, and documents in the custody or under the control of the authority. B. Make a copy of the whole or any part of those accounts, records, and documents. And C. Require a person who holds or is accountable for those accounts, records, or documents to give any information or explanation that the Director of Audit considers necessary. And then the Director of Audit may report to the President of the Legislative Council the results of the examination. Members, any questions? Legal advisor. 22(3), the Director of Audit may report to the President of LegCo the results of the examination. Is it that the Director of Audit's report has to be tabled in LegCo? Can you also include this arrangement here? Yes, Chairman. Yes, we agree that if the Director of Audit has compiled a report, he has to table the report in LegCo. And so the report would definitely have to be tabled for LegCo's reference. Now, members, I think time's up. Because there is only one clause under Part 7. Because we have said that we want to adjourn by 6:25. But of course, if members want to continue, we can. But I don't know how much time we will need to spend on clause 23. Now, as we are going to have further meetings, I think we should pause here. We can continue next time. And I think we'll ask the administration to provide written responses. Then AOB, next meeting, 29th of June, 10:45 a.m. in conference room 2B. So the meeting is adjourned. Thank you.